Okay, welcome back to our final panel of the day. So the SEC's whistleblower office is making headlines every week lately, it seems. And we have a truly extraordinary panel here to discuss it all and wrap the day up. So our moderator for this panel is Bridget Moore. Bridget is a partner at Baker Botts, and she's also co-chair of that firm's litigation department. Bridget was previously a staff attorney in the SEC's Division of Enforcement, and she's just a real pro in the enforcement space. And we're very fortunate to have her here to moderate. Welcome, Bridget.
Thanks so much, Bruce. I'm so happy to be here.
From the SEC, we have the Jane Norberg, who many of you already know has been the chief of the SEC's Office of the Whistleblower since 2016. She joined the SEC back in 2012 after 14 years in private practice. She is the perfect person to have on this whistleblower panel, obviously. Jane, thanks so much for being with us and welcome.
Thank you. I'm glad to be here.
Our next panelist is Lorin Reisner, who is a partner at Paul Weiss. Lorin has extraordinary experience in both the SEC world and the DOJ world. He previously served as chief of the criminal division of the U.S. Attorney's Office for the Southern District of New York, and also as the deputy director for the enforcement division at the SEC. Lorin, it's always a pleasure to have you with us. Welcome.
Great to be here, Bruce. Thank you.
And finally, we're very fortunate to be joined by Jordan Thomas. Jordan's a partner at Labaton Suturo. But Jordan previously served as an assistant director and as an assistant chief litigation counsel in the SEC's Division of Enforcement, where he also had a leadership role in development of the SEC's whistleblower program. Now at Labaton, Jordan has been a real leader in representing whistleblowers in many precedent-setting whistleblower awards and cases, including the largest whistleblower award in history. Jordan, it is always terrific to have you with us. Welcome.
Thank you. I just want to say that thanks to Jane, as of Friday, that's no longer true. It's the second largest, and I'm unhappy.
Well, I would be unhappy too, but Jane, thank you for making news on Friday. And Bridget, I'll let you take it away.
Great. Thanks so much. Good afternoon, everyone. I really feel like they've saved the best for last here. The individuals on this panel really do cover all aspects of the whistleblower process. So let's just jump right in. If you have questions, shoot them over to me. Let's make this interactive. It's always a more constructive and interesting panel when that happens. So with that, Jane and Jordan, you both had significant roles in designing and executing the whistleblower program. So Jane, starting with you first, I'd love to hear from you how you believe the program has evolved over the last 10 years. And then Jordan, I'd love to hear from you about when the whistleblower program was being conceived, what the concerns were at the inception and kind of how that all shook out as the years went on.
Absolutely. And for the last time today, you'll hear the disclaimer that anything I say here today are my own views and are not necessarily reflective of the views of the commissioners or the other commission staff. So to answer your question, the program was put in place to incentivize individuals to bring information regarding misconduct or other violations of the federal securities laws to the commission. And I think the program has been successful over the last 10 years. Just to give some stats around the program over the last 10 years, and then in particular, I'm going to focus a little bit on this past fiscal year, which was a record-breaking fiscal year for us. So in terms of tips, and this goes through fiscal year 2019, and I know a little later we're going to talk a little bit about what we've seen in fiscal year 2020. But through the end of fiscal year 2019, we received over 33,000 whistleblower tips in fiscal year 2019. We've received tips from every single state in the United States, plus 123 countries outside of the United States. So just a global reach to this program. Most common allegation categories have remained the same actually year over year, relating to corporate disclosures and financials, offering fraud and manipulation. Last year, we did start keeping stats on the cryptocurrencies. And so in this annual report to Congress, which will come out mid-November, actually just a couple weeks from now, that will have the most updated stats and will include allegations around the cryptocurrencies as well in the whistleblower space. So far to date under the program, we have paid a total of 108 whistleblowers over $675 million. In fiscal year 2020, it was a record-breaking year for us. So it was our highest year, not only for amounts awarded, dollar amounts awarded, but also for the number of individuals awarded. In the past fiscal year, we awarded 39 whistleblowers more than $175 million. And just to express why this is a record-breaking year, when you're thinking about the number of people we paid, 39 whistleblowers, that's actually triple the number of individuals we awarded in any other fiscal year. So we really put in place some efficiencies, took a look at the program and figured out how we could move awards forward quicker, and we're able to really put that in place this past fiscal year. And I'm very pleased with the amount of awards we were able to get out the door. So in addition, and this is actually in a new fiscal year because the SEC's fiscal year ends at the end of September. So last week, the commission announced its largest award to date, which is over $114 million to one individual whistleblower. And in that particular case, that individual reported concerns internally. And then after the company did not take any actions, then reported to the commission and to another law enforcement agency. That individual's information was not only significant to us, but the individual also provided continuous ongoing assistance to the staff and suffered professional and personal hardships due to that individual's whistleblowing. So there were two facets of the award. Approximately $52 million was connected to the SEC's action. And then there was another $62 million award arising out of a related action brought by another agency. Because under our program, we can pay not only on the SEC action, we can also pay on a related action if another agency brings a case and it's out of that same information from that same whistleblower. But, you know, the one thing I wanted to highlight is whether a whistleblower is getting $50,000 or $50 million, the information is incredibly helpful to our enforcement efforts. You know, to date, based on information that whistleblowers have provided to us, based on those 108 whistleblowers that we have paid to date, more than $3 billion in financial remedies has been ordered against wrongdoers. One other thing I wanted to highlight, and I would be remiss if I didn't highlight the fact that the commission recently adopted amendments to the whistleblower rules, and they were intended to increase transparency, efficiency, and clarity of the program. We could literally spend this entire panel just talking about those rules, but because we have a lot to get to, I just wanted to just kind of bottom line it. And in my view, those rules really, the amendments are really should allow the commission to get more money in the hands of more whistleblowers quicker to incentivize them to keep reporting the tips to the commission.
Great, thanks. And Jordan, what do you think? I know, for example, privilege, reporting inside versus outside were all issues that we read lots of articles about, and just wanted to get your viewpoint on the issues that were flagged and kind of how it all shook out.
Sure. Well, I can tell you that, 10 years in, those of us who were involved with it, including Lorin, who was working on the rules and everything with us, we're proud of where the program is. Back when we started, we were optimistic. We didn't know kind of how it would play out. And I think the numbers and the size of the awards, that's probably not surprising. People were very concerned about culpable whistleblowers and whether they should receive an award or not. And I think the commission was very Solomon-like in coming up with a way to basically not reward people for their own misconduct, but to encourage them to speak up about conduct around them without providing them amnesty. I think that that balance is held, and I don't think that people are critical of that. People also raised issues about internal reporting. They were concerned that all the wonderful sort of things in Sarbanes-Oxley that organizations have put in place might be undermined by the program. And Jane and her offices have released statistics saying that more than 80% of whistleblowers continue to report internally first. And in our practice, we see it over 90%. So I think that concern turned out not to be real. Looking back at kind of things what we thought, I think there was one area that we got wrong. There were concerns raised about can the SEC handle the new kind of an increased number of tips? And when we looked at it, we were like, we're already receiving 30,000, receiving a couple extra isn't going to change it. We're adding people to Office of Market Intelligence, so it shouldn't be an issue. But what we were focusing on was the front end of the process. Poor Jane came in after us came up with these wonderful ideas, and she ended up with saying, okay, how are we going to deal with the whole administrative back end of this thing? And we didn't give enough dollars and bodies to this. And it also put the leadership of the enforcement division and the commission in a horrible decision posture, because to give Jane bodies, they're pulling cops off the street. And that's a horrible dynamic. And, Jane and her team have worked around the clock to kind of solve that. But it's a thing that I think that if we were to do it over again, I would try to come up with a different funding mechanism for that office to ensure that the leaders didn't have to make that choice between cops on the street and supporting that office. Yeah.
Really interesting. Thanks. And Lorin, I think one of the most interesting things about these panels is kind of getting some of the inside baseball about kind of how the program was established. And you had shared a story with me earlier today about your involvement in that. And I think it would be interesting for you to share if you don't mind.
Sure. Thanks, Bridget. But let me start by saying, I've always thought of Jordan Thomas as maybe the James Madison or the Thomas Jefferson of the whistleblower program. But now he's Solomon. I like that. There's Solomon. Like maybe that's what we should. Maybe that's the way we should think of Jordan.
If Steve Cohen is in the audience, Steve Cohen is Solomon. I don't know who Solomon's best friend was in the process. That would be me.
Well, you're definitely one of the founding fathers, Jordan. So I listened to Jane talk about $675 million to 108 individuals over the last 10 years. So Rob Kuzami and I hired Sean McKessie to head the whistleblower office in February of 2011. And I remember interviewing Sean on the 5th floor in the SEC building. And I had many conversations with Sean after he was hired about, how to succeed, what would make the whistleblower office a success. And we agreed that the whistleblower office would only succeed when the first whistleblower award was made. And it took some time. So Sean was hired in February of 2011. The first whistleblower award was August 2012, almost a year and a half, almost exactly a year and a half later. And it was frustrating, I think, at times before the first award was made. But the first award was made in August of 2012. It was a $50,000 award. And our reaction was, this is great. This is fantastic. The program works. We just awarded $50,000 to a whistleblower. And I think that really was the beginning of what has turned out to be just an enormous success for the enforcement division, for the SEC, for Dodd-Frank. This was and continues to be a big responsibility for the commission, and not an easy task. And I just think that the agency has done a wonderful job of handling the policy issues, the process, the bureaucracy, and the advancement of the division's enforcement efforts as a result of the program. So, congratulations to Jane and her team.
Yeah, absolutely. Such an important part of what the commission does. So let's switch gears. I'm going to stick with you, Lorin. All right, you get a call from a client that has a serious whistleblower complaint that's come in over the hotline that you helped them establish, and it's about the financial statements of the company. What are your top 10 do's and don'ts when you're approaching that engagement?
Yeah, well, I told you, Bridget, I tried to come up with 10, and I was only creative to come up with 8, creative enough. But here were the 8 that I came up with. The first is, you've got to take whistleblower claims seriously. Respect the whistleblower. As one general counsel of a Fortune 50 company has described it, you got to hug your whistleblower. There are just enormous benefits of treating whistleblowers with respect and care and thoughtfulness. So that's number one. Number two, investigate thoroughly, but proportionately. First, thoroughly, but proportionally. What do I mean by that? There's no one size fits all. You need to understand fully all the facts and all the issues. You should use company resources to conduct investigations where they're available, internal audit, investigations groups, general counsel's offices, other business units that can participate in investigations. Try to be efficient, but you've got to be thorough. Look, you may not always need outside counsel, depending on what the issues are, to conduct investigations. Sometimes in-house counsel should be handling certain types of investigations. And I think a good outside counsel will give good advice on the limits of their involvement where possible. So number two is investigate thoroughly, but proportionally. 3, interview the whistleblower whenever possible. The whistleblower is the best source for understanding the issues clearly and quickly. You can ask the whistleblower for documents. You got to be careful not to put the whistleblower on the defensive. Be supportive and open-minded. Give assurances that the company is absolutely dedicated to getting it right. And at the same time, while you're communicating with the whistleblower, giving them the support that you should be giving to them and getting the information that's going to be useful, you need to assume that everything that you say to the whistleblower is going to be reported back to the SEC staff. So be smart in your interactions with the whistleblower and be proud of the way that you conduct yourself with the whistleblower during investigations. 4th, have ongoing contact with the whistleblower where it makes sense. A lot of this depends on whether the whistleblower is what I call institutionally constructive or institutionally destructive. What do I mean by that? My experience is that most whistleblowers are institutionally constructive. They care about the organizations that they've worked for, where they're internal to the organization. They don't want to rip apart the organization. They just want to get things right. And the organization should embrace that. So where possible, I think staying in contact with a institutionally constructive whistleblower is a smart policy. That doesn't mean you report to them on the investigation. You almost never do that. But I think, staying in contact is often a smart thing, particularly, as I say, where they're institutionally constructive. There are some whistleblowers that are institutionally destructive. Sometimes they're outsiders who would like to see the company harmed. Sometimes they're short sellers who would like to see the institution diminished. In those types of circumstances, it may make sense not to have an ongoing line of communication because there's very little to be accomplished. Next on my list, don't try to guess the identity of the whistleblower where the whistleblower is anonymous. That is usually much more distracting than helpful. It misdirects resources in directions that are not useful, and it also, it runs counter to to protecting the anonymity of the source, which is often, if not always, in the company's interests as much as the agency's interests. Next on my list is be mindful of communicating with the SEC and self-reporting. So self-reporting to the SEC early and thoroughly can be a very good strategy, particularly if you know that the SEC is communicating, or you strongly believe that the SEC is already communicating with the whistleblower. It can be very smart to be proactive and open up a line of communications with the staff where you can, where you know who they are, or by reaching out to leadership of the enforcement division to find out whether there's a channel for communication. But there are going to be other instances where it isn't wise to initiate contact for a host of reasons. In particular, if A, you're not sure whether there's been contact, and B, you don't think that the whistleblower claims are substantiated, or you don't think that they're significant after your thorough investigation. So in those cases, the smartest strategy is probably not to engage, but be ready to engage in a moment's notice, or be ready to respond in a moment's notice when the staff may reach out to you. Next on my list is report results in a way that's most helpful to the client. Again, there's no one size fits all. Sometimes you want to do a full-blown written report, a formal report with references to exhibits and the evidence and interviews and interview memos. Other times you want to do an informal oral report to the general counsel or the leadership of the company or the board. Sometimes you want to do something in between, a PowerPoint presentation, a short oral presentation with handouts of key items. Again, there's no one size fits all. You need to think about what's going to best serve the client's interests depending on the particular circumstances. And the last item on my list is don't do anything that can be potentially construed as limiting communications between the whistleblower and anyone else. Most importantly, the SEC staff. Be mindful of Rule 21F17, respect it, and don't do anything that could be construed in any way as limiting those communications. So there's my top 8, Bridget.
That's good. We'll let you off the hook for the last 2, but next year we want a complete list of 10. It's really helpful because, in my opinion, at least, and in my experience, these whistleblower complaints that come up are really, the company is in a defensive position, and it's kind of a mad dash for information, and having those types of guidelines, Lorin, I think are so important and really kind of empowering for a company. So thanks for sharing those. Jordan, to you, in your experience, when does a whistleblower reach out for counsel? And what's your process of determining kind of the issues that have legs and those that do not?
Well, I think that the first kind of way in which we look at these things is kind of like speed dating. We're looking at a lot of different people coming to us, and we're just trying to decide, are they crazy? And is there a securities violation that's alleged? So we kind of give them the benefit of the doubt that, at least initially, that what they're saying is true. But if it's true, is it a security violation? Is it significant? And then if we kind of get through that, then we go to the next stage using the dating analogy of kind of going on a date and kind of spending time with their evidence. And then the last stage is very much personal. We're trying to get to know them and see if we want to tie ourselves to them for 5 to 7 years. Not all whistleblowers are people you want to tie yourself to for 7 years. And so, I joke that it's kind of like the guest bedroom rule. If your whistleblower was jammed up, would you let them stay with you for a week? And if your answer is, I'm not so sure, then maybe you shouldn't have them as a client. I didn't have that view in the beginning, but after working with one particularly difficult whistleblower, I said, no matter how right they are, no matter how much money, I just don't want to be tied to these folks for 5 to 7 years. And so we spent a lot of time thinking about the fit of the client with us.
Mm-hmm. And do you find that with the whistleblowers that reach out to you that they for the most part have already tried to get the company's attention, or what do you see? Is it a mix?
That's a part of the question I missed. I'm sorry. So I think that you have two different sort of people that become external whistleblowers. I believe that you have some that are motivated by empathy. They're concerned about the victims. They're troubled by the practice and the potential impact on the organization that they love and have been part of for a long time. And that's what leads them to want to have a conversation with outside counsel like myself. The other group of people are people who are what I'll call in a situational dilemma, okay? The number one reason that people come and report externally is that they perceive that they've been retaliated because they saw something and said something because the company told them to do that. But there's also people who are in a workplace where people are doing bad things around them, and they're concerned it's going to come back on them, or they're in a situation where they feel like they can't advance because people are cheating and somehow moving up the ladder. So those are the two reasons. They tend to come. More of them come after they're put in a situational dilemma than those motivated by some sort of empathy. 75% of my clients are insiders, and so does that give you a sense?
Yeah, absolutely. And that was my next question, is kind of the breakdown between what you see in terms of insiders in a company and third parties.
One other quality that's very common in our clients and maybe across the board for securities whistleblowers is they tend to be very smart. To a person, they're very smart. And I joke that they're also the kind of people that if they got a 95 on the test and if there was one question that they think that they got wrong, but they think that they actually had the right answer based on the question, they're the kind of people to raise that issue with the professor. And I'm not that kind of guy, but whistleblowers that we represent tend to be.
Interesting. Thanks. I think that a lot of the questions that the practitioners get in this area, I'm sure you get them, Lorin, and I'm sure you get them, Jordan, is about a process and how long is it going to take, and what is this? What is the whistleblower? What is the process? Jane, can you talk to us a little bit about the TCR process and kind of just obviously that would take the rest of the time, but from a high level, kind of what the milestones are in terms of the life of a whistleblower complaint?
Yeah, absolutely. So the commission gets lots of tips. So I'm going to speak to only the whistleblower tips because not every tip that comes in the door is a whistleblower tip. And what makes something part of the whistleblower program is if they fill out the right form and check the box and say, yes, I want to be part of the whistleblower program. Not everybody has to be and not everybody wants to be. But those that do want to be need to check the box either on our electronic TCR portal, tips, complaints, and referrals portal, or they can fill out what we call a form TCR, which they can print off our website and send to us either via mail or fax to us. So when we get a tip in, every tip in the commission, including whistleblower tips, gets triaged by our Office of Market Intelligence. On my staff, we don't have the numbers of people that we need to take a look at every whistleblower tip that comes in. Office of Market Intelligence, that's all they do. And they are experts in many different areas. They have accountants, they have attorneys, they have all kinds of people on their staff to take a look at each of these and to make the connections and do the research they need to make the connections. So the ones that they review that are specific, timely, and credible enough, those will get passed on for further review, either through our Division of Enforcement, perhaps to our Office of Compliance Inspections and Examinations for potentially for an exam, or trading markets, or wherever it's appropriate to send. If one gets sent to the Division of Enforcement, if it's a whistleblower tip, and if it opens a matter, that is something that may make someone eligible to receive an award if they hit all the other eligibility criteria. So once an investigation is open, my office serves as subject matter experts to investigative staff as they're going through their investigation, mostly on things like confidentiality, which is always a big concern, especially if you have an insider whistleblower and investigative staff wants to go back out to the company and ask them some questions, and how do we make sure that we're being really careful to protect the identity of the whistleblower, because obviously that's a big thing for the program, so that people feel comfortable and safe reporting to us. In addition, we also serve as subject matter experts on retaliation matters, 21F17, agreements that might impede. So we get questions about all those things a lot, and whether certain fact patterns look like they could support a charge in those areas. So if the tip then leads to a successful enforcement action where there's over $1 million in monetary sanctions ordered, then we post on our Office of the Whistleblower webpage every matter that is over $1 million ordered in an enforcement action. It doesn't mean that every single matter that's posted has a whistleblower involved. We just post everything just in case. And so for those matters, if someone applies for an award in those matters and they have 90 days from the date it gets posted to apply, then we have a snapshot of how many whistleblowers applied for that particular matter. We can have none. We can have one. I think we've had as many as 15 apply for one particular matter. And that's where, the real heavy lifting that Jordan was talking about at the beginning of the panel begins for my team, because we have to take a look at every single one of those applications for awards and look at the eligibility of every single whistleblower on that matter. And if we have more than one whistleblower who is eligible, then we also have to figure out, well, what percentage should be allocated to each whistleblower, because the commission can pay between 10 and 30% of amounts collected in that matter, and it has to be allocated amongst the successful whistleblowers. So that's really how the life cycle goes from the moment it enters the TCR system until the end of the process when the commission issues a final order to the individual whistleblower.
Got it. Thanks. That's helpful. And what is the average time is that somebody could expect that process to take?
It really varies because it depends on if the tip comes in and it's immediately something that gets passed on. It might move a little quicker. It is possible that we might get a tip in that in and of itself isn't material, but then all of a sudden we get 5 or 6 or 7 other tips in, say from harmed investors or something, and then all of a sudden it looks like, okay, there's something happening here and it's material. And then it might get passed on, and that can take, weeks, months of time. And then, of course, it depends on how long the life of the investigation goes. Whistleblowers certainly have in the past helped us move things much quicker, saved resources, gave us a lot of information that we wouldn't have otherwise had, pointed us to witnesses, documents, other things. And that certainly does help move those investigations a little quicker. But it's really hard to put a particular time on from the minute you put in your tip to the minute you get an award if you're eligible, how long that might take. But certainly it's not months. You should think of it in terms of years.
Sure. And, and I think that the commission's been pretty clear, right? If a whistleblower hires somebody like Jordan, right, who helps kind of package everything, that certainly helps the process.
I mean, look, Jordan is a great attorney, but I don't want anyone to walk away, any whistleblower to walk away thinking that they must hire an attorney, because It's not required under our rules. Certainly, anybody could benefit from the counsel of an attorney, but you don't have to have one to be a successful whistleblower under our program.
Right. Good clarification. Thank you for that. So I would love to hear at this point some war stories from Jordan and Lorin in terms of maybe a matter that stood out for you most in this area and some of the lessons you learned from it. Jordan, if you could kick that off.
I can just give you some things that I see people doing that I think is in an era of whistleblowing, I think it's a big mistake. The first thing I would say is prior to the SEC whistleblower program and the cooperation program, which we haven't talked about, the risk of detection was less. And so companies, when they became aware of wrongdoing, would sort of ask the question, how likely is it the SEC is going to know? And if we report, is it going to even be better for us or worse for us? Those sort of questions. I think that the analysis is much more difficult now that there are whistleblowers, and the SEC whistleblower program is far more well known, because I think that the odds of someone reporting wrongdoing is higher. The second thing I would say, and kind of echo something that Lorin had said, is for whatever reason, it is like corporate crack to want to know who is the whistleblower. And I know that sophisticated counsel tell people not to care and not to look, but for whatever reason, it doesn't get to the people who are near the traffic accident. And those are the people who I think you should be really concerned about, because they're the people who do things that hurt the whistleblower and the company later. Another thing that I would say is that people are very focused on traditional mechanisms for internal reporting. And in my observation, because my clients are using these mechanisms and the way the commission measures these things is they look to the people who are their supervisors, the people who are just right above them in the organization, people who are in a related area. And the cultures in organizations people from reporting, but for whatever reason, being told that supervisor is not thing to the people who can fix the problem early. And so that's something I would encourage people to pay attention to, and encourage people to report hearing from their subordinates. Another thing I would say is we've done some surveys. The last one we did was with the University of Notre Dame, financial service professionals. And it's shocking what people are saying. And it's very inconsistent with the view of most organizations that think that they have a wonderful culture and everybody would report. There's a lot of distrust. And so I think that a wise organization surveys of awareness of wrongdoing, willingness to report, whether the people believe the organization will do the right thing.
Got it. And Lorin, is there a particular engagement or some lessons learned that you can share with us?
Yeah, to me, you know, and I've had this happen a few times. The most satisfying thing is when I've interviewed a whistleblower during the course of an internal investigation, having the whistleblower say to me at the end of the interview, you know, I went into this thing very skeptical and not trusting of this process, but I thought you asked good questions. I thought you listened to me. I thought you heard me out. You asked me some interesting questions that I hadn't thought about before, and made me think that certain things that I thought might have been black and white weren't black and white. They want, I'm not saying they back off their claims or their position, but I think that done the right way, you can help the source of the issues establish some context, and you can advance the interests of your client and the interests, frankly, of the agency as well. So maybe it's it can't be done in every situation, but in a number of instances, as I say, it's been very satisfying to get a reaction from the whistleblower that they were being heard, they were being respected, they were being listened to, their concerns were being taken seriously by the company, and they saw in action a company acting responsibly in response to issues that were raised. So that's always the goal. It can't be accomplished, but it is attainable now and then.
Bridget, one thing I would just add is, remember I said that my experience of whistleblowers is they tend to be very smart. And I gave you the example of them wanting to kind of question that one question. Yeah. When an organization they don't feel responds appropriately, they're more likely to go external. And so it's just another reason why you want to hug and listen to the whistleblower, because that may end it. But for a smart guy or gal who thinks that there's a problem and everybody's kind of saying there's no problem at all.
Right.
They want proof that what they see is real, and they go
Right.
to someone who will listen. And that's a very expensive mistake.
Yeah, absolutely.
And if I can just add to that, I think that's very true. And in our last annual report to Congress, we did note that of the whistleblowers that had been paid to date, that of those whistleblowers, 85% of them had reported internally before they came to us. That's a huge number when you think about that. And I've personally heard from whistleblowers who have said, I really like my company. I've been here for, in some instances, decades, and really want the company to succeed, and became very disenchanted, just very disheartened when they found that the company was not going to correct something, especially where there were investors being harmed. That's, I think, was really, the thing they felt like people that they cared about were losing money, and that really bothered them. So I do think that that's true. The one caveat I would throw in there is that with the digital realty decision, with the Supreme Court decision, with retaliation, whistleblowers now have to report to the SEC in order to put down that benchmark, or that line in the sand, basically, that they are now protected under the Dodd-Frank whistleblower protections for retaliation. So you may find that some people might still be reporting internally, but they might also be reporting to the SEC at the same time in order to protect themselves, just in case some retaliatory action is taken. So that has changed the dynamic a little bit when it comes to the timing, I think, of reporting to the SEC.
Sure. Yeah. Thanks for pointing that out. We have a question that I'd like to throw out. So the question is, do you think recent changes to the SEC whistleblower program concerning what constitutes original information will have a meaningful effect on future rewards and incentives for outside whistleblowers to come forward?
I'm not sure if it's asking it, if it's in the negative or in the positive. I mean, I actually think the rules clarify it, which I think is very helpful for any whistleblower. I would rather know upfront, looking at the rule, what do you want from me in order to be eligible for an award at the end of the day? And so I think it clarifies what the commission is looking for original information. What they don't want is for someone just to sort of forward something that is a public document and say, this doesn't look right. They're looking for some analysis. They're looking for a little bit culling together of information and showing us something that wouldn't be evident by looking at the face of the document. And we have made 2 recent awards, actually, to outsiders who did this exact same kind of thing. I mean, they pulled together information, they did some analysis, and they sent it to us. And it definitely showed us something that you would not have seen just by looking at the document itself. So I don't really see much changing in that landscape, but the rule never said that you can just send us some public information and you'll get paid. I think the intent was to clarify.
Got it. And Jordan, any response to that based on your practice?
We represented 2 Wall Street analysts who received an award recently, who are outsiders. And so for those types of outsiders who provide sophisticated analysis, I don't think the rules change anything. If anything, they say, please keep coming. I think that there are some concerns by whistleblower advocates that the rules now have an after-the-fact analysis. Would the commission have known? Could they have gotten there? Which is a concern, which for sophisticated outsiders is going to make them think twice. But the other kind of dynamic is, I suspect, Jane hasn't said it, but I suspect that they've been getting a lot of low-quality outsiders who are seeking awards that don't get awards, and that's causing them to spend a lot of time that they don't want to. And so by putting the rule and emphasizing kind of the quality they want, hopefully that narrows the number of low-quality tips that are coming in and ones they have to deal with in the back end. So I sort of get it. I wish they didn't have a back end dynamic to it, because I think that hurts because it makes it more uncertain for whistleblowers.
Got it. That's helpful. And unfortunately, we've come to the end of the panel. I feel like we have enough to talk about for the next hour or so, but I wanted to thank you all so much. I hope everybody listening found it as informative as I did. And thanks again to the panel.
Bridget, thanks to you for doing such a great job moderating. And to the panel, what a great way to end the day. Terrific topic and just a great blend of people to really take this issue on. So thank you. We hope you'll join us in 5 minutes when we'll release our Enforcement 40 list for 2020. That's Securities Docket's list of the 40 best securities enforcement defense lawyers. Just quickly, thanks again to everybody at Ankara Consulting for again being our lead sponsor. I'd like to thank our friends from Cornerstone and FTI Consulting and John Reed Starr Consulting for your support and sponsorship of the event. On the law firm side, thanks to Cahill for being our lead law firm sponsor and to the 23 world-class law firms that were represented here today as sponsors and supporters of the event. So I guess mainly thank you all for joining us today for this virtual event. Hopefully we'll be in person soon. And please join us back here at 5:30 when we honor the Enforcement 40. Thank you.